Might be Friday night for you, depending on where you are. First sip of coffee is on point. All right, let's go ahead and get into it today. Today we are talking about generational wealth trust, offshore generational wealth trust. But one of the things that pops up quite often is grantor or non-grantor, right? Which way should the trust be structured, grantor or non-grantor? The vast majority of our clients are structured as a non-grantor offshore trust, right? The difference is tax related. It's the IRS for U.S. citizens that define whether a trust is grantor or non-grantor. Okay, so if you want that definition, you'll head on over to irs.gov, and there'll be a search bar up in the corner, and in that search bar you can type either grantor or non-grantor trust, and it will give you the IRS's working definition, right? Now, since the majority of our clients are American, this typically affects them from a position of paperwork and making sure that they're compliant, right? So, if you have a grantor trust, there's a couple things that comes with. If you have a grantor trust, you can touch the trust. All right, you can stick your fingers in it. You can pull money out of it. Probably, you're probably the trustee. You might be the trustee and the beneficiary, and you can make a lot of day-to-day decisions about the trust. The trust is typically weaker. Okay, so it's easier to attack a grantor trust because anything you can touch, a judge can order you to touch, right? So a grantor trust is typically weaker from the viewpoint that a judge can possibly order you to get into that trust and pull money out to satisfy debts, personal debts, even, or personal judgments. For example, you get into a car accident and there's a judgment against you that exceeds what your auto insurance is willing to pay, or you're an uninsured motor, worse yet, right? So those types of things are some of the kind of basic ways that sometimes a judge might make a ruling um, that you got to reach into a trust and pull things out. Now, if you are operating a grantor trust, there are a ton of paperwork compliances that you have to file annually. Okay, so you'll have to file forms with the IRS annually. You'll probably have to file a FinCEN report. Um, you may need to do an FBAR. All right, these are all IRS forms. Okay, you'll probably have to disclose where the bank accounts are and all of that stuff, and any other information that they might ask for you from you. Okay, a trust tax rate is incredibly high, incredibly fast, right? So if you are being taxed on a trust, you will hit the maximum tax rate at something like $24,000, right? Way quicker than you would an individual or a corporate tax rate. That is why, in general, trusts hold assets or provide a safe place for them to mature, and businesses build assets, okay, typically. And it's because the top business uh, tax rate, it's going to take you a heck of a lot longer to get to than the top trust tax rate. All right, so a trust is never really a tax savings vehicle for your standard taxes. Does it maybe help with inheritance tax? Yes, that's a different situation. But your active, taxes that you're dealing with on a yearly basis, a trust is not really a tax vehicle. It's actually a tax neutral vehicle. So anyone trying to, push a trust as some kind of way to save on taxes is essentially pushing fraud. There's some sort of fraud in there if they're utilizing their trust in that way. Now, can trusts have tax exempt income and tax exempt distributions, and can you set it up where the possibly the distributions coming out of the trust are tax exempt on both sides? Yes, but it has nothing to do with it being a trust per se, and has everything to do with it being offshore. Because typically the people who are doing that, they're getting some kind of foreign earned income exclusion attached to the trust, or they're getting some kind of foreign tax credit attached to the distributions of the trust. And so that's where they're wiping out the U.S. tax liability within, the law. And then on the side where the trust exists, like for us, our generational wealth trusts, under the local law where the trust exists, is allowed to give out 10 million in distributions a year, tax exempt. So on that side, it's tax exempt by statute, and on the other side, it's tax exempt by statute, right? So your tax people are going to break all of that down to you, depending on where you live, what's available to you. We can break down local to the trust jurisdiction. We obviously have CPAs and accountants and all that here, so we can break down, what's available to you on this side. You have to get a local person on your side if this is going to be an international trust, to figure out what all your local and state and federal, and depending on where you live, provincial or whatever, if you're in Canada or whatever, all those taxes, how that works out for you. There's no way we can cover the rest of the world. Every county, different counties have their own county tax, state tax, local tax, all of that stuff. You need a local guy who's going to be able to guide you in that. And they need to be certified, right? So you need a certified local guy. We have certified local people here. So we have no problem giving tax advice here because we have certified tax professionals and certified legal professionals here to do that. We do not have individuals in every county in the United States and every province in Canada, and so on and so forth. So most of our clients are US, Canadian, UK. So you guys have to have your local tax people. All right, disclaimer. Okay. For as far as the generational wealth trust is concerned, we got you covered on tax people here. All right. So that's how that works. It's not by virtue of having the trust, it's by virtue of the treaties between the territories, right? And how the money leaves the trust and makes it to you, whether it's earned income or not, right? And those things don't happen just because you say they happen. I see a trend of that, like people using like the language of like the tax code and or the language of something to be like, oh, see, so it's a foreign earned income exclusion. Your trust has earned income foreignly, so it's excluded. That's not how it works, right? You can't try to play with the name of the thing, or play with the text in the code even to figure out how it works. To figure out how something works, it has very little to do with knowing the IRC 179, very little to do with that. What it has to do with is knowing the Treasury decisions, right? So you can take that IRC 179, whatever, blah, 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 and then go find the Treasury decisions and see what the court says. And that's what's going to dictate. It's not going to be, oh, I can match the language that's in the code with the activity that I'm doing. That doesn't guarantee that it's a tax exempt or tax deducted or tax anything situation. You got to go actually check the Treasury, which most of these folks don't even know how to do. So make sure you have a actual professional on the ground that knows how to navigate your system. But by virtue of placement, all your stuff might be tax exempt, okay? A lot of our folks are in that situation where all of their stuff is tax exempt. Remember that your foreign earned income exclusion is now it's over $130,000, right? It goes up every year. So first $130,000 of foreign earned income is excluded from taxes. If you can meet the test, right? There's a test. There are tests for these things, right? That's why the names don't matter. Right? So if you can meet the test, which is what your professional is going to assist you in doing, obviously. Okay. For the foreign tax credit, I think it's 90%, now. I think it just changed to 90%. It used to be 80. So it's 90% of the taxes that you paid, you might be able to file a credit against. Like, all right, look, I paid my taxes, in Kenya. So 90% of the taxes paid up to my tax liability in the United States, there might be some kind of credit in place there. So again, local person, got to get that squared away. All right. But the idea that a trust saves you in taxes because it's a trust is bullshit. Plain and simple. Okay. So anyone who's pushing that, stay away from them. They don't know what they're talking about. All right. So your structuring may have some active tax effects for the trust itself. It might flow into you if you're the beneficiary, depending on how you're being paid out of the trust. But if it's a grantor situation, you're going to have a ton of filings that you're going to have to do as a grantor, because you are in charge of essentially all of the tax filings for the trust if it's a grantor trust. Okay, now when it's a non-grantor trust, which is typically what our clients like to have, not all of them, everybody has a different situation, but most of them. In a non-grantor trust, your fingers don't touch the pot, right? You don't actively engage with governance of the trust. Okay, most non-grantor folks are in two positions. They're either not in the trust at all, as it's a generational wealth trust, and so what they do is they have a trustee company that's the trustee. They're the ones who wrote the trust deed, which is the document that governs everything that happens in the trust, right? So they write the trust deed with the assistance of our professionals, of course. And the beneficiary is either their children or their grandchildren, right? That's super, super clean non-grantor trust. Absolutely. You're not even in the trust. You have no say beyond the first creation of the trust and how the trust will run. You have no say of what's going on in the trust, none of that stuff, and there's no distributions going out to any U.S. citizens, because the trust is compounding generational wealth for the next 30 years, 60 years, whatever the case may be, so that there's some money for your kids. Cool. Classic, 100% non-grantor, not even a gray area, right? Typically those folks will either do one payment, which takes longer, right? So they'll do one payment into their trust, right? And that one payment will compound forever. Okay, so the ROI on that one payment will be compounded and compounded and compounded out for the 30 years until whatever is in there is in there. Okay, you can calculate it if you know the ROI and all that, but whatever is in there is in there. Other folks want to make payments to the trust and build it like a 401k. The problem with that is if you keep putting U.S. assets and U.S. money into the trust, you risk violating the definition of non-grantorship. So how do you deal with that? So we have methods to deal with that so that it's clear, easy, and whatever. Typically there's some sort of waterfall investment that's placed into the trust from the beginning, and it's the investment that's making monthly payments, not the person anymore. And the trust owns the investment. So again, no U.S. assets or anything like that being pumped in, all foreign assets being pumped into that trust, and you can't touch it. It's probably the biggest part of the test. You can't touch it. Non-grantor. No problem. All right. There can also be a trust set up where you're the beneficiary, right? So now it boils down to when you take your distributions, and sometimes even how, right? But definitely when you take your distributions. Anytime you take a distribution, you're going to have a compliance documentation that becomes due with the U.S. Internal Revenue Service, right? So when you take a distribution, there's a filing that has to happen. When you're not taking a distribution, if you don't control the trust, right? So you're the beneficiary, not the trustee, still have the corporate trustee in place. You're not putting U.S. assets in there, right? Typically the same type of situation with some sort of waterfall method or bond laddering or something like that. that's paying the trust monthly, right? Then you're still in a real solid non-grantor situation. Okay, if you decide I'm going to be the trustee, then pretty much non-grantor is off the table. Right? At which point you can be the trustee and the beneficiary if you feel like it at that point, and just have no protection whatsoever in the trust. Because at that point you can be ordered by a local judge to reach into the trust and pull out whatever the judge tells you to and give it to whoever the judge says has the right to it, right? So whether it's a credit card, a debtor, whether it's a judgment, you know, a claim against the estate, whatever, whatever, the privacy, or not even the privacy, the protection of the trust is shot at that point. If you're the trustee and the beneficiary, it's over. Even if you're the trustee, you weaken it quite a bit. Because if you're standing in front of a judge and he orders you to do something, you got to do it. If your trustee is a corporate trustee and you're standing in front of a judge and the judge orders you to do something, you got to do it. But the corporate trustee can just say no. So that, a judge can still order you to go into your trust and pull something out, and you should comply with the judge's order. But the trustee, who is not in that judge's jurisdiction, can just say no. It just depends on how you have the trust deed written. Right? So that's where the protection comes in. That's why offshore trusts are way more protective than uh, local trusts, because a local trust is under the same jurisdiction where you might run into a problem. And the problems are not always problems that have anything to do with you, right? The probably the most common problem is a car accident, which is exactly that, an accident, right? But if it's determined that you're at fault, which we've seen a lot of these new like fraud cases where a car gets in front of you and slams on the brake and then says you hit them in the back, right? So, and then if that stands, if you hit them in the back, you're 100% at fault, right? So there's a lot of that type of nonsense going on where it may not even be your fault at all. But now here you are in a situation, they've, searched your assets, they found that there's a trust or whatever, and now the judge is saying, your insurance isn't covering this. You owe an additional $1 million. I'm going to order you to go to the trust and have them, give you everything that's in it to satisfy this judgment. And if that trust is domestic, that's what's going to happen, right? The judge is going to make an order. Everyone in that judge's jurisdiction is going to follow the order, and that's going to be the end of that. But when the trust is overseas, the trustee can literally flip the judge the bird. It doesn't matter, right? You can make all the requests you want, but depending on how the trust deed is written, that trustee can just say no, period. And that's the end of it, right? So simplified, the other side might try to, the most motivated thing that we've ever seen is the other side try to come register the judgment in the jurisdiction of the trust. That doesn't work either. Well, it might work in some places if you pick a bad trust jurisdiction, right? But that's part of what your professionals are supposed to be about. So depending on the jurisdiction, some jurisdictions will require the party who's trying to register the judgment to put up a significant amount of money. We've seen it as high as you need to put up $1 million bond with the state to even bring the action, right? Because you don't pay taxes. So you using up their judicial system is actually costing them money. So you have to put up a bond that, what you're bringing isn't frivolous, just to even bring that action. So that happens in certain jurisdictions. Also, you typically have to have standing in the jurisdiction, right? Which means that the thing either had to happen in the jurisdiction, or some aspect of some asset owned in the jurisdiction had to be involved. Typically, has to also be a crime, you know, or a civil offense in that jurisdiction as well, right? And so most of the times it just doesn't work if you strategically pick the right jurisdiction. They don't really have standing to register the judgment there. There are other places though where you can just register a U.S. judgment and they'll just allow it, right? Like if your offshore trust is in Canada, right? The Canadian government is going to go ahead and acquiesce to whatever the American judge is requesting, right? So that doesn't make sense. It's not strategic. So it's not just about being offshore. It's about knowing which jurisdictions operate under, which laws, and how they protect you best. And sometimes, depending on what's in the trust and the purpose of the trust, there's a jurisdiction that might be really really protective for asset protection, but doesn't do a whole lot for generational wealth, right? Trust, right? Or maybe is really really good for non-real asset protection, but if you put a house in that trust and now there's a real asset in it, that might change everything, right? So there might be trusts that are really really good at IP protection, not so good at real property protection, so on and so forth. So even knowing a decent jurisdiction doesn't mean that it's the right jurisdiction for your specific trust. So really, really, really important that you have professionals working with you on that, right? People who offer specific trusts, like us, right? We offer generational wealth trusts. They normally have a jurisdiction that makes a lot of sense for the exact specific type of trust that they offer, right? So that's typically why they're not offering you 3 4 different places. We only offer different locations for completely different trusts, right? And those clients are maybe, I don't know, they might be 2% of our business in numbers, but they're really good clients, right? They're not afraid to spend money. So they're more of our bottom line than 2%. They're maybe like 2% of our clients. So those folks have at least $1 million in assets that need to be under management, right? Not just $1 million in assets, but in assets that need to be either protected or managed under the trust. They start at 1 million, and sky is the limit, right? So they're a different category of client, and because of the robustness of the protection that they need for those specific assets, those assets are held in other countries. Yeah, if you're gonna have specific high value assets, then part of the due diligence on that becomes what's the case law regarding these specific assets in those specific countries, right? And then you go from there. All right. Okay. What do we have here? Okay. Why would you choose grantor or non-grantor if you cannot touch the money in the trust? What's the point? Okay, so the idea, well, first off, if it's a true generational wealth trust, you're not worried about touching any money in it. It's not for you. That's number one. Let me just start there, right? But number two, you write the trust deed. So you have controlled how the money in the trust works and how everything else in the trust works before any of that stuff ever existed. So before there was any money in it, you decided how the money would be used. Before there was any assets in it, you decided how the assets would be used. You decided the rules of how people get it. You decided what they have to do to qualify. You decide everything up front before anything is in that trust. All right. So you're in complete control of how the trust is utilized. That's why people use them, even though it removes them from ownership. Being removed from ownership is also being removed from responsibility. When the responsibility is legal, we call it liability, right? So it's legal responsibility, right? So what ends up happening is as you're removed from that ownership, you're then also removed from responsibility. All right. So that's the big part of why, people would want to do that. It also removes them from having to do those tax filings, right? So essentially it removes them from tax liability. Okay. So that's the most important part in that. Um, So you're still in control of how all the money and all that is used in there. But generational wealth trusts are not necessarily designed for you to benefit. Okay. Can you be the first beneficiary generation? Yes. That happens more in trust estates than anything else. So if you're going to create a trust estate, a central, almost like headquarters for your family, because most of the trusts are, about the bloodline in the family. I suppose it doesn't have to be your family, but for your organization or your whatever, you're going to create a centralized location. There's going to be local tax benefits on that location because of the type of trusts and the type of laws that we use on the local level. Okay, then it might make sense for the person creating the trust to be the original beneficiary. Still, no one can force anything out of them, even if they started the trust and they're the beneficiary, because they're not the what? They're not the trustee, right? So even in that situation where the trust estate has been established, and they're still utilizing a non-grantor trust, the trustee is still the one who's calling the shots, even though they're only allowed to call the shots based on what was created in the trust deed. So you're the one who set the rules, so you know what they are, and you know if your trustee, does anything crazy or anything like that. But your trustee has to execute those rules based on the way you set them up. All right. And the only time that you're dealing with any kind of filings that are going back to the U.S. or anything like that is when a distribution is made to you, or when you transfer a U.S. asset to the trust. Right. So if you transfer a U.S. asset to the trust, that'll trigger a filing event, and if a distribution is made to you, that'll trigger a filing event. Okay. That's fine. You can do that. There's plenty of people who do grantor trusts. But if you can touch it, anyone you owe can touch it. Just know that. There are a lot of people where it's okay. That doesn't matter to them. And, they'll do it anyway. And that's fine. As long as you're aware of how it works, your choice is fine. You can choose, any way that you want to go. You just need to be informed on the choice. That's all. An example, it's all in structure, right? So you could have a trust that's owned by a corporation, right? Or that the trustee is a corporation that you own. So, and so you could have a trust where that's being, operated by a corporation, and that corporation could be offsetting a lot of its, taxable income through dividend received deductions, right? So you could have a C corp, for example, that has a trust, and there are some other companies underneath that C corp, probably companies that the trust own as well, and that C corp has a 10% ownership stake in all of those companies, and the distributions from those companies to the C corp may qualify for a DRD, right? A dividends received deduction, which is 100%, by the way. It's 100% tax deductible if you qualify, right? You have to hold the stock for a certain amount of time and the blah, 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 blah. But it's a structure. It happens. Only C corps can do it. So you could have a situation where you don't care about the tax filings because on the other side of your structure, there's a deduction available in the tax code that allows you to wipe out enough of it to make it worth your while, right? So you could have a situation. Now that's just looking at it from that tax perspective, right? That doesn't necessarily negate that you might be more exposed from a liability perspective, right? That's why you have to have all of your professionals in one place, because half your professional team's going to be like, well, wait a minute, what about the liability of this? And the other half is going to say, all right, cool, we can cover the liability of that, but what about the taxes of this? Right? So you got to find the things that make the most sense to you and have all your professionals cover all your bases, and then say, okay, now we're in a place where we're comfortable that this aligns with, your future goals and what you want, and so on and so forth. Right? In a non-grantor trust, the trust is responsible for its own taxes. In a grantor trust, the grantor is responsible for the trust taxes. That's why you have all those extra filings you have to do. Right? So in a non-grantor trust, even the concern of taxes is removed from you, because now that's the trustee's wheelhouse, and you're not the trustee. Right? So it just depends. It just depends. Anyone who's telling you this is the way you do it, this is the way the rich people do it, this is the way that they're lying. It's different for every single person by design. By design. It's designed so that if you don't have a team, you screw up because you don't know what you don't know. It's designed that way. All right. No, not so much. Typically, beneficiaries have their own, tax situations, and they just handle their tax situations. If a beneficiary gets a distribution, then that's income. So that's going to be treated however that local code says that distribution has to be treated. There might be ways to qualify the distribution, right? So where it's under a certain tax regime versus another tax regime. Like if it's considered um, um, like W-2 income, right? Then that's going to be treated way more harshly from a tax perspective than like capital gains income, right? And so there may be ways to qualify it under multiple different, tranches of income in your tax code, depending on your local tax code, right? So like our UK clients do completely different things than our Canadian clients, who do completely different things than like our US clients, and even within the US, the different states, like California is horrific. So like the different states make you do different things as well, right? I'm trying to think which states are the worst in our experience. Sometimes the Carolinas will try to jam you up a little bit. California definitely. New Jersey's a little weird sometimes, especially if you sell a house and leave New Jersey. It's odd. The last time we dealt with it actually seemed as though you had to pay to leave the state. Like if you sell a house and don't buy another one, or if you sell your primary residence and don't buy another one, there's like a fee for that. So some of the states are just weird, and so they'll try to jam you up because you'll know your federal situation. Most people know their federal situation. What jams them up is their state situation. So if you take on the responsibility of the trust as a grantor trust, that you're now doing federal filings for the grantor trust, right? Those federal filings may be viewable by the state, right? So now the state starts asking about this trust, possibly, right? And so now you got to navigate the state's, tax system, about this, offshore trust or whatever. So if you're a grantor, you're taking that on. You're taking on that you're responsible for the taxes of the trust, right? You can also typically touch the trust, which means that there's an avenue for someone else to get to the trust through you, right? So a suing attorney that sees that you have a grantor trust knows that there's a pathway to that trust through you if the trust is grantor, or at least assumes it. You could have a real like put together trust deed and maybe be blocked. Maybe there's multiple trustees and you're one of them, which would still mess up your status as far as grantor is concerned, or non-grantor is concerned, but might give you some additional protection as far as someone trying to go through you. Maybe 3 signatures are needed, not just one, blah, 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 blah. The other 2 people aren't in the jurisdiction and they won't give the signature, so on and so forth. But, that's a matter of planning. From a high level perspective, if it's a grantor trust, there's a way inside, right? There's a way to break the trust, and try to get some of those assets out, through judgment, through creditors, through debtors, through all of that, right? So if it's non-grantor, then the assumption is there's no way inside, just from the jump, right? So, and especially, like attorneys that are going to be working on contingency, they see that and they're like, whoa, we need to settle this thing because I'm not waiting 10 years to get paid. Because there's no way in this trust. Even if we get a judgment, we have to wait for a distribution, to utilize a charging order to intercept the distribution, right? So those are the different assumptions that we've seen made, over the past decade and a half when it comes to people who are in a situation and the trust becomes something that's starting to be looked at as a solution for that situation. If they're grantor trusts, normally it goes ahead whether or not they break the trust or not, depending on the trust deed, and I suppose the lawyers that you have in play at the moment. But it typically goes ahead. They typically go after it. If it's non-grantor, they typically forget it. They typically don't go after an offshore non-grantor trust. So that's just the protective power of the trust, essentially. Yeah, same answer. It's the innate protective power because they haven't seen the trust deed. But they'll assume that it covers the basics if it's an offshore trust. Like an offshore trust isn't something that you like stumble upon by accident, right? It's a strategic move. So it says something about the owner of the trust, right? And so it's one thing to like, oh, there's a land trust in Florida. All right, well, we're going to get into that trust because possibly that person created their own land trust and screwed everything up. And they just gave us everything on a silver platter. That's a different thing. Like a domestic trust, someone can decide, like, you know what, let's really get into this. Let's spend the money to really look into this. Because maybe they went to ChatGPT or some nonsense and decided to generate a trust deed and thought that it was actually accurate. And so that would be great for them. But when you have an offshore trust, that's not something that you go to some Department of State website and build, right? So that already shows that you're strategic, right? And that you're of substance, even if you're not, right? Because a lot of our people are not particularly rich because they do generational wealth trusts. That's designed for people who are not, rich. But just the fact that you have an offshore trust, it's way more strategic than any local thing that could happen. So it causes attorneys to pause. What's going on from Texas? How's it going today? Too hot in Texas. Well, no, it's not. Well, I mean, I'm sure they do, right? But here's the thing with that, right? With the whole thing about like, Are you using the trust in some kind of nefarious way to block X, Y, and Z? Um, and are criminals using trust to like get out of whatever? The thing with the trust is, and again by design, but the thing with the trust has to be in place before you're in trouble or it doesn't work. There's something called a seasoning period on a trust. And then from outside the trust, certain government agencies and certain governments have something called a look back period, which means they can look back in time and see if the trust was there enough years ago, right? Like Medicare has a 5 year look back period, right? So, or Medicaid. So, those things have to be covered. So typically your seasoning period is going to be like 2 years. So your trust needs to exist 2 to 5 years before any problems happen. Right? That's why planning and strategic people and people who care about their future and get into it right away will always have a better experience than reactive people. Always, always, always. Right? If your trust has been set up and it's been set up way before any problems arose, your trust is stronger than any prenup. Your trust is stronger than any business contract. Your trust will weather all of those storms. I saw you with Traverse Culture founder. She's really good. Yeah, 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 yeah. Yeah, no, she's awesome. Yeah, she's awesome. She has a really good program, really good relocation program. Focuses primarily on apartment seekers. So our clients are slightly different. She is she's doing some development though as well. So yeah, yeah, pretty decent. On this side of things, on the trust and all of that side of things is really where we shine. For her, it's the medical tourism side of things. We don't do any medical tourism. That's really where she shines. But she has a great organization. Um, Love those guys up in Nairobi. We do more the coast than than that, but yeah, yeah, great organization. We have a lot of fun together too. Isn't she my competition? No, I'm my only competition. We have completely different clients, right? Our clients might think they're the same because our clients might be like, well, I want to come to Kenya. Her clients want to come to Kenya. But our clients want to come to Kenya differently than her clients do. But that's how it is in everything. If you're worried about other people who are in your industry, um, then you're not really executing your plan. You're reacting to their plan. What do we just say about reactive people? What is their experience like compared to strategic people, right? So you don't want to let anybody else dictate what your business plan is. You don't want to let anybody else dictate what's going on in your house by reacting to what they do in their house, right? So no, we definitely don't have to, be at each other's throat or be competing against each other when we can collaborate, which is exactly what we do. Now we collaborate with only her because she's the only relocator in the diaspora that's legit. So now, and I know there's a bunch of new kids on the block, and we don't sit there and send our lawyers out to double check everybody. But of the, I suppose the people making the most noise and the people who have approached us for deals and stuff like that, we of course do our due diligence. And then you'll have people talking about they're gonna get you a permit, relocate you over here, and they ain't got no permit. They operating on visas themselves and working illegally and doing all kinds of nonsense over here, right? So we would never connect ourselves with somebody who's operating, below board. So as far as the diaspora relocators, they're the only other legit ones. So that's why they're the only other ones that we partner with at this moment. There are others who haven't, crossed our radar who want to collaborate. That's fine. They can always reach out to us. As long as they're above board, we don't have a problem collaborating with anybody. But yeah, it's just them and us for now. But yeah, it was a good time. I was with them. When was I with her? I was with her like maybe 3 days ago, actually. Sure. Yeah. Sure. Sure. The difference between so the difference in the compounding between the bond laddering trust and the non-bond laddering trust, absurd. It's an absurd difference. Absurd difference. For example, if you put, I don't know, $1,000 in the trust and you let it compound for 60 years, you might have $280,000 in the trust at the end of 60 years because you're only compounding on that $1,000, right? Okay, fine. It's something, right? Turn $1,000 into almost, over $250,000. That's great. If you had a bond ladder in the same trust, it would be 3.2 million, 3.8 million. Completely different because the bond ladder is paying every month. Every month there's money going into the trust on the bond ladder. So of course your compounding is going to be absurdly different than someone who just puts one payment in and whatever. But either way, both of those people still impacted generational wealth in a legitimate way for future generations. You know what I mean? So, it might be that they just don't have it to be able to do a bond ladder. Some people are in that position, but they still care about their future generations. They still care about making something happen, um, you know, for their heirs and their descendants. So they do what they can do, and it is what it is, right? Um, and that's fine. Something's better than nothing, as the old saying goes. And it's still substantial. You still took $1,000 and turned it into almost $300,000, right? So it's still pretty substantial. Took a long time because it was a small amount of money, but it's still a pretty substantial, compounding over time for the next generation. But if you got a bond ladder running inside of that trust, that bond ladder is paying the trust every month, right? It's paying the trust ROI every month, paying dividends every month. It's called coupon payments with bonds, but same thing. So it's paying those dividends every month. And so your compounding is accelerated, right? It's accelerated by 12. You're getting 12 additional payments every month. So it's times 12 compounded by the amount of years. So it's a whole different number. Yeah, and it's also a whole different amount of time. That 3.8 million actually isn't based on the 60 years like the 300,000 was. That 3.8 million is going to hit in about 30 years, even less than that, maybe 25, because you have the ladder going. So in less than half the time, you have 10 times the money, but you're making 12 times the contributions. Not even, because it's 12 times compounded, because you only made one contribution. So in the first year, you made 12 times the contributions, but in the next year, or 11 times the contributions, but in the next year, you made 12 times, and then the year after that, there's an additional 12 times. So at that point, it's like 36. Every year, it compounds. It's not just another 12. It's the 12 plus the 12 plus the 12 plus the 12 for all the years going back to the beginning, right? It compounds. So, yeah, by the end, it's ugly. So it's a huge, dramatic difference. Minimum bond ladder. There isn't one if it's generational wealth. Now, there are things called amortizations. So if you're not in a bond for a certain amount of money, it might amortize. And if it amortizes, then they give you all your money back and you leave the bond earlier than maturity. Some people are cool with that because some people will then use the bond almost like a CD. So they'll be able to buy into the bond, and instead of having 20 years of illiquidity, because while your money is in the bond, yes, you're getting paid, but you can't pull your money out of the bond without losing money. If you go to the secondary bond market and try to get liquidity on a bond, you're going to lose overall. Right? So some people are like, okay, cool. I'll just purposely put in under the amount of the amortization. And so instead of being in that bond for 20 years, I'm only in it for 3 years. Right? So I'm still getting that real high rate of return right now anyway. The bonds are really high rate of return locally. So I'm still getting that high rate of return, but I've now put myself in a position where the amortization is going to kick me out of the bond before maturity, but there's no penalty in that. I just get my principal investment back. Whatever money I put in, I get back early, and I make the interest I'm supposed to make up until that point, right? So some people actually do that on purpose. Folks that want long-term growth are looking to stay in the bond for the full maturity, right? Like if you're creating a trust for your grandkids, and it's going to have 30 to 60 years of compounding on it, you want all 30 to 60 years. So in that situation, then you need to be over the amortization point, right? So that's the only time when there's really like a minimum on the bonds. The minimum to get involved in a bond would be something in the neighborhood of $500, right? So not much. And the minimum to have a functional bond ladder would be 6 of those, right? So that's it. So $500 6 times is what, 3 grand? 3 grand, and you're getting like a payment every month. Now that ain't nothing you can live off of, right? So like if you look at like our end of year special with the relocatees, they're doing the amortization minimum. So since they're doing the amortization minimum, they can actually relocate here, stop working, and live off of the bond because that's a relocation special, right? So they want to live off of that money, not grow the money in generational wealth. But if you're just growing the money in generational wealth, you could literally build the bond ladder. It wouldn't pay anywhere near as much as those relocated people, get paid. But you could build the bond ladder and literally have minimum bond payments in there. It wouldn't last as long because you're going to get amortized out at that point. So but when you're amortized out, you get all your money back. So you just throw that into another investment. The downside is the bond interest is so high right now, right? 12, 13, 14%, right now that you can get for 20, 30 years, that when you are amortized out and they give you all your money back and you go back to reinvest and build more, wealth, those interest rates might be 7%, right? So that's where you end up kicking yourself for not going all in, is that by the time, you've gone through your proof of concept or whatever, and now you do want to go all in, now the interest rates don't support what it is that you wanted to do. So, fortune favors the bold. Those folks who act typically make out the best. Those folks who don't act typically have regret. It's just the way it is. All right. Any other questions on that today before I end this bad boy? Any members of the Freedom family got any questions for me on non-grantor versus grantor offshore trusts? Do you have to pay tax in the trust jurisdiction when the distribution is made? Maybe. It depends on whether the distribution is more than 10 million. Right? So for the specific type of trust that we utilize here, each beneficiary each year gets the first 10 million in distributions tax free, which is part of the overall strategy, right? Because if you can have a foreign earned income exclusion, or if you can qualify for a foreign tax credit or any of those things, um, and you're getting a tax credit here, that might actually hurt the foreign tax credit, but whatever. Um, if you have the foreign earned exclusion, or if you qualify for a credit or whatever, um, then here you're not paying any taxes at all, and there, whatever your local tax professional is telling you qualify for could eliminate or reduce any taxes that you pay there. The dividend received deduction is, what is that? Are you saying it's only domestic? Yeah, you have to look up foreign dividends received deduction. That's correct. It is domestic. And the example that I gave earlier, it wasn't a domestic structure, remember? The domestic companies owned everything. And then there was the offshore trust that was owned by a company that the domestic trust owned, remember? Yep, just look up the foreign version. Still need a C Corp. Well, that's a question for your local guy, because even your county taxes might affect that. That's why you need your local taxes and taken care of. I have no idea. I don't even know where you're from. I'm not even sure what state. If you're American, you can be Swiss for all I know. So that's the problem with the internet stuff, is people who try to talk to you like they know what's going on with you are just full of shit. How could I know what your local tax laws are? Yeah, but even you telling me, why would I be an expert in every single location in the world, their local tax laws? That's why you need a local expert. State's not even enough. The county, we have clients in PG County that are doing stuff with like land deeds and all that, and PG County has special laws for how land deeds transfer. That's not Maryland. It's the county has its own tax rules and requirements and all of that in order to transfer title deeds and stuff like that. So even knowing the state isn't enough. You need a local person, a local tax person that understands your county taxes, possibly your city taxes, and your state taxes, and then all of your tax people are going to understand federal. But you may even need to get a federal specialist that understands international and what international rules apply to federal taxes. So you're going to have to understand what tax nexus is, tax residency is, and things like that. And so your professionals got work cut out for them. That's what they're paid for. All right. Any other questions? This one was short and sweet. We're getting all wrapped up here. Any other questions on any of that? Right, not local tax questions. I can't answer them. I don't know. Got Kenyan tax questions, we can answer that. All right, looks like we're good. If you're looking to ask something, throw a one in the chat, or if you're in the process of typing something, just hit enter and I'll let you go fix it up. But if we got all the questions answered, everybody understands the difference between grantor and non-grantor, and some of the examples of what we've seen in the past as to how that affects you, then I think we're good to go. All right, looks like we're good. All right, guys, great talking to you guys. I will be here tomorrow, same time, same place.